here at SandsAnderson, we do a lot of different types of local government law, zoning, tax assessment, public finance, employment, all kinds of things. Most of my practice is really in advising local governments in various ways, but specifically in defending them in zoning, land use cases, and in tax assessment cases. So a lot of what I'm going to tell you is very general, but it's informed by my larger practice in defending local governments in zoning cases. Where did zoning and planning come from? Really, back in the 17th century, we'd just gotten past the God makes a king, a king, and a king can do no wrong. And we'd gotten through a nasty English civil war in England, and there were a lot of English philosophers at that point in time discussing political philosophy as to, where do we go from here? Since, it's no longer the divine right, what does give government the right to rule and under what circumstances? And out of that, there are really two themes that emerged. One is sort of, hey, I have individual rights. The government really can't tell me what to do. And the other is more, what we consider in the zoning and planning world, NIMBY, not in my backyard. I want government to protect me. And in the 17th century, the two philosophers that we point to most directly are Thomas Hobbes and John Locke. Hobbes basically said that people are nasty, brutish, greedy, and they need to be protected. Other people need to be protected from others, and so you need to give power to the government in order to have public safety. Alexander Hamilton was a big believer in the federal system, and he's a good example of a Thomas Hobbes follower in America. John Locke, on the other hand, was a great defender of the rights of the individual. He actually wrote the English Bill of Rights on which a lot of our Bill of Rights was modeled. And he wrote that the power of the government is only legitimate when it has consent of the people through a social contract. And essentially Thomas Jefferson adopted his philosophy for much of the Declaration of Independence and, of course, for the Bill of Rights that went into our Constitution. Historically speaking, zoning is an extension of the concept of prohibiting public nuisance. Back in England, Judge Blackstone wrote that a nuisance is anything that unlawfully worketh hurt, inconvenience, or damage. And so essentially, the legal theory behind zoning is that we need to stop nuisances from harming the community. Therefore, we're going to pass laws that prevent specific types of nuisances within districts, and thus we will protect the health, safety, welfare of the citizens. In the 13th century, Britain required highways leading to the market to maintain a buffer area, thus reducing dust and things like that. In colonial America here in the United States, we had various rules that banished offensive things and dangerous things to the outskirts of the municipality or had setbacks. At historic Jamestown, there were rules that were passed to require that wells be a certain distance from certain types of activities. And if you've been down to Colonial Williamsburg, you've seen the powder magazine is out in the middle of a field, basically in the heart of Colonial Williamsburg, accessible to the people, but if it blew up, houses wouldn't be damaged. Later on, we had fire districts after great fires to prohibit wooden buildings, required setbacks between buildings. And really throughout the history of, sort of our modern age, the law has often weighed the rights of the individual property owner with the rights of his neighbors and with society. And we call those the police powers. They are the health, safety, welfare protections. And out of that grew sort of modern regulation of land use. In 1889, a Wisconsin statute authorized cities to create districts with building regulations. D.C. was one of the first places to adopt building regulations. In 1909, there was a very tall building that was erected that scared everybody because it was so tall it cast this enormous shadow that was unexpected. And so they adopted height restrictions at Copley Square, which were later held to be constitutional. Out of that grew New York City's attempts to have the first comprehensive zoning ordinance that was adopted in 1916. That led to a push to have a sort of a zoning enabling act and model ordinances available to states and local governments, and those were in fact adopted across the country, mainly by municipalities initially and later by counties. Zoning was upheld in the Euclid versus Ambler case because the question really initially was, can you do zoning, with the takings clause? The takings clause says that you can't basically take land or real estate without just compensation. You can't take property without just compensation. Well, you've not allowed me to do something that otherwise I would be able to do. Haven't you taken my property? The Supreme Court said, well, they haven't taken it because they haven't taken all the economically viable use. And so thus upheld the constitutionality of zoning in Euclid v. Ambler in 1926. Similarly, later that year, Gorey versus Fox was decided by the Virginia Supreme Court that also similarly upheld the legislative authority under the police power to do zoning. Zoning basics in Virginia. We are not a home rule state. A home rule state is where the local government can do anything that the state constitution prohibits. That's in some other states, but not here. We are a Dillon rule state. A Dillon rule state is a state in which there is a strict limit on what local governments can do. It has to come from above, essentially, from the state down to the local government. Under the Dillon rule in Virginia, local governments have the powers that are expressly granted by the General Assembly, or necessarily or fairly implied from expressly granted powers, or essential and indispensable. And then there are other creatures of statute that really are just limited to express powers, such as boards of zoning appeals. Why is that important? Why is the Dillon rule important? Well, acts that violate the Dillon rule are ultra vires, means that they're beyond the scope of authority and they are void. They're not just voidable, they are void. And the ultra vires, Dillon's rule doctrine is a common law doctrine, and it has to be changed expressly by the General Assembly. And so anytime there's a question about that, it's important to look to the express language of statute to see if they intended to waive that or grant that authority. Existence of the authority under the Dillon rule is construed against the local governing body. And so when local governments are doing zoning in various ways, it's important to look for the statutory grant of power and stay strictly within that authorization. Follow the procedure. Understand what your authority is. Why do you do that? Well, if you've acted within the statute as provided, then the legislative acts are given deference, and they're generally upheld by the courts. A fairly recent case, Sinclair versus New Singular Wireless, was a case where the Planning Commission was held to have acted outside of its authority under the statute and struck down what had been a fairly well-recognized, well-used authority of the Planning Commission in Albemarle County to grant steep slope waivers. They now have a different way of doing that is consistent with the Sinclair case. Okay, the zoning ordinance. In the zoning ordinance, all regulations have to be uniform within a particular district. Typically, there are residential districts, there are commercial districts, industrial districts. Over the years and decades of zoning, they have gotten very complex. In the first zoning ordinance in 1916 in New York City, there were only 3 zoning districts. Now it's fairly common to have 12, 14, 104 zoning districts, depending upon how sophisticated the locality is. But the regulations of one district may differ from another, and even within that district, there can be text that allows different uses, different things within that district, depending upon what is stated. The distinctions have to be non-arbitrary. They have to be allowed by ordinance. You have to sort of treat equally stated people equally, but of course what is equal is really a decision that the Board of Supervisors makes in the first count. and then they need to express a rational basis for that difference. Various types of approvals under a zoning ordinance, text and map amendments. The text of the zoning ordinance obviously controls unless the text is amended. Map amendments is what we would commonly call a rezoning. You want to change your zoning district. There are also conditional use, special use permits, which are not changes in the actual zoning district, but they're changing of the regulations within that district with a special permit. Variances are special exceptions that are granted by the Board of Zoning Appeals. There's administrative waivers if authorized by the zoning ordinance. In some localities they are. And then, of course, administrative determinations by the zoning administrator. There's just lots of different ways you can do zoning within a zoning ordinance. Procedural issues, where the legislature and the Planning Commission are considering map amendments and text amendments, they have to follow the procedural requirements. And the primary statute on that is Virginia Code 15.2-2204. It has a specific requirement on the specificity of the type of advertisement that needs to be made, the timing of the advertisements. It's very important because there have been a lot of cases that have suggested that the statute is strictly construed by the Supreme Court, so it's important to ensure compliance. Lack of compliance means lack of procedural due process. It's invalid. It is void. Void ab initio, like I said. Advertisements are usually taken care of by staff, advised by the local government attorney. If, in fact, the act is authorized under the Dillon Rule, it's adopted procedurally according to the statute. Because it's a legislative act, it's entitled to a presumption of validity. And a court is not going to substitute its judgment for that of the legislative body. The legislature is seen as a co-equal branch of government, and under the separation of powers, courts are reluctant to second-guess the legislative decision-making of a governing body in a locality. And under that view, acts are upheld as long as they are fairly debatable. In other words, there is some evidence of reasonableness. If the act is not fairly debatable, it's considered arbitrary and capricious. Arbitrary and capricious is a term that simply means there is no reasonable basis for that act. It's a fairly low standard. It's fairly easy for the local government to overcome. Typically, with the presumption of validity, local governments will prevail. There's special species of arbitrary and capricious action like spot zoning. Spot zoning means it's one or a small number of parcels that zone differently from established zoning patterns or the comprehensive plan's recommendations, but it has to be solely to serve the private interests of one or more of the landowners. That's why we rarely actually see a spot zoning in Virginia. It is a special kind of arbitrary and capricious. All there has to be is some reasonable basis. If it's solely to serve the private interests of one or more landowners, there is no public purpose. It is arbitrary. But if zoning furthers the overall welfare of the county or city as part of the zoning plan, it's not spot zoning, even if private interests are simultaneously benefited. Downzoning. Downzoning is and can be an exception to the legislative presumption in favor of a legislative act. The legislative action in downzoning is reducing the number or density of the permitted uses within the zone by a zoning or a text amendment, or by changing the designation of one or more of the parcels on the zoning map to a less intensive category. This does quite often change the presumption for legislative validity. If a local government has done a downzoning and there is a lawsuit brought within the 30 days, then there are two different standards that apply for legal review, depending upon whether it's a comprehensive downzoning or a piecemeal downzoning. A comprehensive downzoning is reviewed under the same fairly debatable standard as every other zoning act. It's presumed to be valid. It's very hard to challenge a local government comprehensive downzoning. However, piecemeal downzonings will be invalidated unless the locality can show that the original zoning was the product of fraud or mistake which is very difficult to do, or that there has been a change in circumstance substantially affecting the public health, safety, or the welfare. Local governments have prevailed by showing a change in circumstances, but it needs to be done very carefully. Certainly, if you are thinking about doing a downzoning that could be perhaps piecemeal, it's important to get good advice from your staff and from your local government attorney. There are further limits on zoning power. For example, unconstitutional conditions. Local government can't approve a conditional use permit or special use permit or a proffer that has an unconstitutional condition in it. In 1987, the Nolan case held that title exactions, in other words, real estate exactions, must bear an essential nexus to the harm prevented. In other words, before you require the dedication of some right-of-way or a piece of the property, or to limit a landowner's ability to use their property in some way, it must have an essential nexus to the harm prevented. That's another way of saying there's got to be a public purpose to the condition. Second of all, the condition under the Dolan case that was decided in 1994, the condition that's imposed has to be roughly proportional to the adverse impact on the project and on the community. In other words, you not only have to have a public purpose, it has to have some basic rough proportionality between the amount of impact on the project of the need versus what the condition actually does. It has to be roughly proportional. That was the rule for a good long time, almost a couple decades. And then in 2013, the Kuntz case was decided, and that extended the principles and standards of Nolan and Dolan to permit denials as well as approvals and monetary exactions. There was a belief for a really long time that Nolan and Dolan only applied to approvals, because if the zoning permit was not approved, there was no condition approved by the governing body, and therefore it couldn't actually, that constitutional principle couldn't apply to a denial. And there was also a belief that it couldn't possibly cover cash, because cash is not the type of property up until that date that had been held to be subject to the Nolan-Dolan analysis. The Supreme Court said it did cover cash, and it did cover denials. The very next year, the Virginia General Assembly essentially codified that Kuntz case in 15.2-2208.1 and allowed damages and attorney's fees for those aggrieved by unconstitutional conditions, and essentially put a presumption in favor of their illegality unless the governing body could prove it wasn't a controlling basis. But the landowner or the person aggrieved has to object in writing in advance. In proffers, conditional zoning was something that was originally come up with during the zoning process. As I said earlier, when there are map amendments, local governments could weigh the impacts on local government and the community, and as long as it was roughly proportional, those types of things could be upheld. It had to be in the health, safety, welfare interests of the citizens, and if it was, the local government could approve a zoning. Back in the early 70s, there were a lot of denials of zonings and rezonings because the concern was there were impacts on local government and their communities, primarily school impacts, transportation impacts, things like that, where if we approve a certain development, we're going to have a bad impact on the community, and we need to have some way to address that. There was no legal way to take cash from a developer. There was no legal way to address that through specific zoning conditions in that case. So there were, over the years, adopted various versions of conditional zoning, which are called proffers. And over the years, it has been very successful, very useful for both localities and developers and landowners to address impacts. It allows a local government to find that a particular zoning application complies with the health, safety, welfare interests of the citizens, at the same time making sure there's a legally enforceable way to deal with these conditions. And there's been revisions over the years to address various concerns that were raised over the years. In 2016, there was a game changer. Landmark legislation passed in 2016 in most residential rezonings, which fundamentally shifted the dynamic from a voluntary, flexible, negotiated set of conditions, which are presumed reasonable like any other zoning regulation, to a sterner, more legalistic process in which the conditions are presumed not to be reasonable, and in which the local governments are at risk for suggesting, requesting, or even mentioning informally what is defined as unreasonable proffers under the statute. And unreasonable proffers is unfortunately defined fairly broadly. I've given you the code section there. I commend it to you. I really think that a strong reading of that with your local government attorney is essential for anybody today doing conditional zoning. The statute itself is very similar to the unconstitutional condition statute I told you about before, but it's really worse for local governments. Not only does it have damages and attorney fees and a remand with mandated approval, like the unconstitutional condition statute, it also allows for informal requests by a locality as opposed to a specific request by the board or the governing body. There's no written warning required under the proffer statute. There are a few exceptions, which I certainly encourage you to take advantage of if you have an opportunity to do that. But proffers are deemed unreasonable if they are residential in nature, unless they address an impact that is specifically attributable to a proposed new residential development or other new residential use applied for. For those proffers in which the statute applies, it really ends the fairly debatable test. And localities have to show some evidence of reasonableness, but they also have to show it by clear and convincing evidence to win. It severely limits the ability of local governments to address off-site impacts and also limits the scope of on-site proffers also. All right, moving on to other limits of local government zoning power. Non-conforming uses. A non-conforming use only occurs when the zoning has changed through a rezoning of some kind, text or map amendment, and it covers an existing use of land or structure that is lawful prior to the adoption of an amendment to a zoning ordinance, which makes it illegal. But because of the provisions of 15.2-2307, it's considered a legal non-conforming use and may continue as is. It may continue or remain notwithstanding that change in the law as long as it's not expanded or enlarged. If a non-conforming use is discontinued for 2 years, it could be lost. And then a non-conforming structure that's destroyed cannot generally be rebuilt, and there are a few statutory exceptions. Grandfathering. Sometimes grandfathering is confused with non-conforming use. As a matter of fact, quite often when you're talking about a non-conforming use, people will call it, oh, you're talking about a grandfathered use. They're actually two legally distinct principles. I've just described what a non-conforming use is. Grandfathering is truly an act of legislative grace as it's applied in Virginia. In grandfathering, a local governing body expressly limits the zoning text change for certain landowners in certain respects. In other words, we hereby adopt a zoning ordinance amendment that says X. However, this will not apply to landowners that have applied for a site plan approval, for example, and thereafter diligently pursue that application, or those that meet a certain time frame. Legislative grace is really subject to what the local governing body wants to condition it to. It can be conditioned on various things, time. The local government can define the class that's grandfathered. Common examples are persons that have an application in the pipeline, those who apply in time, etc. Why would somebody do this? It can help avoid lawsuits over vested rights and non-conforming uses by granting those with the largest stake in the proposed zoning amendment sort of an exception to that, and it's a flexible rule. Vested rights. What is a vested right? A vested right under 2307 is one that belongs so completely and definitely to a person, it can't be taken away from him without his permission. It's an ordinance amendment that may not affect the landowner who obtains or is the beneficiary of a significant affirmative governmental act which remains in effect, allowing the development of a specific project, who relies in good faith on that significant affirmative governmental act, and who incurs extensive obligations or substantial expenditures with a diligent pursuit of the specific project. That's the basics. Believe me, there's a lot. I could talk all day just on vested rights. What is an affirmative governmental act for affirmative governmental approval? Acceptance of proffers, proffered conditions which specify use, approval of an application for rezoning for a specific use or density. Not any rezoning complies with that. It has to be a specific use or density. Granting of a special exception or a conditional use permit. Approval of a variance by the BZA. Approval of a preliminary subdivision plan, plat, site plan, or plan development with diligent pursuit of a final plan thereafter. Of course, approval of a final subdivision plat or plan. And under limited circumstances, a zoning administrator's written order, requirement, decision, determination that changes the landowner's rights is relied on the landowner, is no longer subject to appeal, and the zoning administrator is stopped under 15.2-2311C. That is a rare beast indeed, but it could be found. Supreme Court guidance. Rules for vested rights. First of all, it's got to meet the statutory test I went over. The rights which vest are those that are affirmatively acted upon, those that are actually within the four corners of the significant affirmative governmental approval, or within the 2311C vesting. And the evidence to support the claim to those vested rights has to be clear, express, and unambiguous. And let me talk a little bit more about 15.2-2311C. Under very limited circumstances, a zoning administrator's written order, requirement, decision, or determination, and sometimes called an ORD, cannot be changed after 60 days with reliance by the landowner. There's a burden on the landowner to prove the ORD and all the other elements, but not every approval by a zoning administrator is an ORD. As a matter of fact, most every single case the Supreme Court has decided that the proposed ORD in that case is simply not one, and therefore there are no vested rights. The Supreme Court also has made clear that the statute 15.2-2311C only stops the zoning administrator and not public bodies, and that was in the James versus Falls Church case. And of course, the right that vests under the statute is only the prevention of the zoning administrator changing his or her order, requirement, decision, determination. One of the questions that's on appeal right now to the Supreme Court is, can an ORD be void ab initio and still provide vested rights? We've got a case on appeal right now that's going to be argued and a decision issued shortly where we believe that issue is going to be decided. We also believe that there will be an application of the 2311C applies to zoning administrators and not public bodies rule. So stay tuned on that. That's really my PowerPoint. Obviously, there's a lot more to be said about zoning. I've been talking for about half an hour. Jonah promised that I would talk for 20 to 30 minutes. I think I've taken up about all the time that he gave me. I'd be happy to take questions or go back over any of the points that I've given. I can dive more deeply into really any of those topics because, like I said, every single one of them has an immense amount of case law and interpretive information behind it. And, of course, I've got personal experience on most of it. So happy to answer any questions that you may have or chat.
Great. Thank you so much, Andrew. I did unmute everyone, so those of you who are on the phone, you have the ability to go ahead and start chatting with Andrew or myself. And for those of you who are online, you can do the same. If you're uncomfortable talking in front of an audience of your peers, you certainly can type your questions in the chat box that appears to the bottom right corner of your screen, and we can take your questions that way. Does anybody have anything they'd like to have Andrew dive into a little bit more deeply? or things that were entirely unclear?
Thank goodness I covered it adequately in half an hour, gentlemen.
No, I can tell you, Andrew does a version of this presentation in our Certified Planning Commissioner program, and we call this portion of the program drinking out of the fire hose. So, if you didn't catch all of that, you're certainly welcome to review this video, or better yet is attend the Certified Planning Commissioner program, and you'll get a much more comprehensive version of this presentation. But yeah, there's a number of things that are, that can be rooted in for hours and hours with this topic.
Well, let me talk a little bit about sort of some of the things that are sort of common things that I see occurring a lot in the zoning process. And I may apply one or more of the things I already talked about. Since there are no questions, I'll just start talking. How about that?
Yeah, and if anybody wants to interrupt, I'm sure Andrew would.
Oh, absolutely. Feel free to interrupt. I'd rather talk about what you want to talk about than what I want to talk about. But over the years as a county attorney in a bunch of different places and outside counsel, I've seen a lot of issues come up in the legislative zoning process where it's just a tough call. There's a lot of times when I've been, for example, the county attorney, I've been sitting on the dais with the governing body, and the Board of Supervisors is asked to make a tough call. There's people who are angry about the proposal. There's solid reasons for approval. There's reasons for disapproval. Ultimately, it's a troublesome situation, and lots of times I've sat there and I've said, what, I'm so happy I don't have to vote on this. But, that's why we elected officials, and that's why the presumption of legislative validity is there, because it is a tough call, and that's why as long as they give everybody due process and everybody understands what is being proposed, everybody has an opportunity to be heard, then the courts are generally going to upheld whatever that legislative body says the law ought to be. The courts are not going to get typically into the merits of a particular proposal. There are exceptions, and I've given some of those limitations on zoning. Obviously, every year the General Assembly meets, and every year seemingly there's another twist on zoning. I would say when I started doing zoning pretty much full-time in the early 1990s, it was a simpler world back in those days. Nowadays, it is much more complex. I think staff has had to be much more experienced and trained. I think governing bodies and planning commission members have had more need of training now than ever. And certainly local government attorneys have been much more in demand than they used to be, just because the presumption of the legislative validity goes a long way. But things like procedural compliance have gotten more difficult over the years. And certainly those statutes I went over and the limitations on conditional zoning have just gotten worse over the years.
Yeah, and when you say worse over the years, it's always fascinating for me to come into this and listen to you as a lawyer. So much of the authority that's provided to local governments really provides a lot of flexibility in how the zoning ordinance can be put together and really bring forth the wishes of the local constituents. So much of what you do from the legal side is really kind of almost filling out the edges of the shadows where, procedural and substantive due process kind of put the edges on the zoning process. But overall, zoning cases don't seem to be voiding the premise of zoning itself. There's not been a lot of cases that would have challenged, the authority of local governments to establish a zoning ordinance or to put specific uses in various districts and those kinds of things. Those cases seem largely settled, and it's now mostly, as you said, sort of refining the edges of the due process consideration. Is that fair to say?
Well, I think that's fair to say. Certainly, again, substantively, there is a lot of flexibility for local governments to define what their zoning ordinance says and how it does. And there are certainly, with good staff and legal advice, ways to address some of those limitations I went through that are of significant concern. And, certainly, there's a certain perspective out there, for example, on the unconstitutional conditions that, local governments don't do that anyway, so what's the problem? And certainly, getting good advice along the way to make sure that you don't trip over some tripwire is really helpful. But you're right, Jonah. I mean, there's a lot of flexibility, and with local government help, local government attorneys can help you sort of define where are the ditches, where's the guardrail, and then, sort of the local government can decide where on the road they wish to drive and what speed they want to drive and what kind of car they want to drive in and things like that, because that's the area that the courts are really not going to get involved in. Just to take that analogy one step further, assuming that you're inside the ditches and inside the guardrails, a court is not going to ask a local government body or get in between, what type of car they want to drive, how fast they want to drive it, where do they want to drive it, as long as there is some reason to be driving. Is there a good rational basis for why you're driving there? And if there is, then the local government body has a lot of flexibility on the road.
Right, and to go to that point, as you were speaking about, as long as there's a public good involved in some of these things, it's pretty hard to see how, like, for example, spot zoning, as long as there's a public good involved and that the legislative body and the planning commission can call that out in their decision-making process, they're pretty much, exercising their authority, right? But there are some gray areas where the law is not quite settled, it seems, and that there have been some, movements on the edges. And I'm specifically thinking about how does something become the public good? When is it a public good and when is it not? And the issue there being if a private developer is going to do something that ultimately creates jobs and increases the tax base, is that not a public good because now you have more tax dollars to do something with? And are developers now arguing that, on one side of the coin, you have the ability for a local government to exercise things like eminent domain in order to increase economic development, whereas on the other side of that coin, it's really sort of a taking without compensation in the interest of a private individual. There's, of course, been some constitutional issues with that, but it really kind of goes against the nature of zoning itself.
Well, there's a lot of flexibility, like I said, on the local government side under the fairly debatable rule. If there's really any conceivable, reasonable basis that this serves the public good, it's going to be upheld. The law even says that it doesn't have to be a stated reason, and it doesn't even have to be a reason that was even known to the members of their governing body at the time. It just has to be a rational basis, and that's because it's not a subjective review. It's not a subjective rule, like what was in the minds of the governing body. It instead is a objective rule, which is, would reasonable people differ on whether or not this is a good zoning regulation or not? And if, in fact, there is at least one good reason for and at least one good reason against, it is considered to be something that's fairly debatable, and they're going to let the elected representatives of the people decide. And as far as what is a public purpose, certainly the courts are going to review that. If there is a accusation that there is no public purpose, for example, in a spot zoning, where, it basically, the governing body is in cahoots with the private property owner, and this has nothing to do with the public interest. It violates our patterns of zoning. It violates our comp plan. It's nothing like anything that's been approved in the past, and you know what? It's really just something that benefits the private property owner. If there's an accusation for that, the courts have to review that allegation, probably have to have a trial on it, and make a decision. It still would be very difficult to win because of the flexibility and the fairly debatable rule.
Does somebody have a question? All right.
Well, you mentioned constitutional takings and eminent domain. I'm specifically not addressing that here today. just because the flexibility that has been true on the land use side and the fairly debatable rule really doesn't apply anymore under eminent domain, or at least it applies a whole lot less. There are specific statutory restrictions in the world of eminent domain, and I would just really ask the people attending the webinar or those listening later to sort of go look into those issues specifically, because what applies specifically, for example, you said increased tax revenues. I mean, that's absolutely a legitimate consideration for a governing body that wants to approve a rezoning, for example. But simply serving the interests of economic development is pretty much forbidden in the world of eminent domain now because of the statutory changes, the constitutional changes that have happened in the last few years. So it's not necessarily a principle that carries over from land use into eminent domain.
Thank you for clarifying that. I think that's an important point to make. I just want to go back to one other thing, unless anybody has anything they'd like to chime in on. Back to the beginning of your presentation, you talked about defining districts. Well, it's maybe a little bit outside the scope of this presentation. What actually does create a zoning district? I know they're sort of defined, by their use classes, but you also have to draw a map here so that people know whether their property is inside or outside of a district.
Right.
How much, or how does that process actually work?
Well, it's as many things that the governing body is supposed to do. Of course, zoning itself is optional. Governing bodies don't have to do it. And some localities in Virginia still don't have zoning. But if local governments do zoning, then they have to follow the rules. And one of them is that they have to adopt districts. They have to define where those boundaries are. They have to have a zoning map. Of course, they have to follow the procedural rules in order to do that, which includes, getting planning commission input and having a decision made. Defining districts is a line drawing exercise. And I mentioned sort of in passing the equal protection rule. There's always sort of those kinds of issues come up whenever a governing body is drawing a line on a map. Let's say it goes down the middle of the street. How come on one side of the street it's okay to use a higher density or have a higher density, and on the other side not? How come it's appropriate to have something higher on one side of the street and not on the other? How come it's okay to have a particular type of use, say an industrial use on one side of the street, but not on the other? From a certain perspective, you could say, well, that's an equal protection problem. They're both fronting on the same street. It's the same community. It's right there, literally adjacent across the street. What's the problem here? And the reason is, like I said, they're just tough calls that have to be made. In order to have a zoning ordinance at all, the governing body has to draw a line. They have to create districts. Therefore, they are given a lot of deference, and all of their review of their districts is under the fairly debatable standard. They have to have a reason for doing it, certainly, but they, that line drawing exercise is given quite a bit of deference by the courts.
And then, as you said, there's the procedural due process that always comes into it. So wherever there is a rezoning, the public is allowed to come, provide their case or their complaint, and redress the government and petition to have their concerns redressed. So it's really an ongoing dialogue back and forth where you have development and needs to be reconsidered in its uses, and all those lines adjust over time. There's no perfect landscape. There's no perfect community, but people have to adjust things over time, and that means that we all have to participate in the zoning exercise. Unless anybody has an additional question, I will create a line drawing exercise of my own and call this the end of the webinar. For those of you who joined us this afternoon, I really appreciate your time, and certainly, Andrew, above all, your time is important to all of us, and so we very much appreciate you being with us.